SJC-12483, Commonwealth v. Jamie Bill Johnson.
Good idea. We should all do that. I think I'm gonna start joining you and keeping you company when you do that.
Mr. St. Lawrence, good morning.
Mr. Chief Justice, Associate Justices, good morning. May it please the court. My name is Tim St. Lawrence and I represent Jamie Johnson. The warrantless search by the government of Mr. Johnson's long-term historical GPS locational data violated his rights under the Fourth Amendment and Article 14. This conclusion is supported by recent cases from this court and from the United States Supreme Court, which have held that a person maintains a legitimate expectation of privacy in the record of their physical movements.
Is that true even if you are on probation or parole?
Yes, it does.
Why? Why? What's the case that would tell you that?
I don't necessarily think there's a case directly on point. However, the distinctions raised by the motion judge, I think if we look at those, we can see that it would equally apply here. So one of the reasons that
Doesn't La France support that? La France, Commonwealth versus La France support that? Justice
if there's a
Wilkins?
reasonable expectation of privacy in the
You don't think it states it itself? La France itself doesn't provide that support?
it provides the support that if this is indeed a search in the constitutional sense, which we suggest it is, then that the government would have to obtain, the police would have to obtain a warrant based on probable cause.
I'm not sure what your argument is. There are two separate arguments, I think. One is that it was unconstitutional for there to be GPS in the first place, and therefore the information should never have been obtained. The other is that there's nothing wrong with him being on GPS. After all, the defendant invited it as an alternative to arguably going back to jail. It was at the defense counsel's suggestion, but that you need a warrant to access that information. So is it both? Is it the second? And if it's the second, then you have to deal with the fact that there's a statute which says probation information is available to the police.
It is the second, Your Honor. The argument is that the search occurred when the police accessed the 5 months' worth of information a year after he had terminated his probation. So as far as the statute that allows information sharing, I think the short answer to that is that statutes do not define reasonable expectations of privacy. This court has said so in Blood, in which the legislature saw fit for a one-party consent to wiretapping of conversations, and the court said, notwithstanding the decision of the legislature, we need to interpret this under the Constitution
But I'm confused,
of Massachusetts.
though. So he asked for the GPS to avoid prison. His expectation of privacy in that data, he knows they're monitoring him. The reason he's not in prison is that they're monitoring him with the GPS. He still has a reasonable expectation of privacy in what? Them using the data at all? Using the data a year later? I'm confused what his reasonable expectation of privacy is.
Sure. Well, I would suggest putting aside kind of the issue of whether one can voluntarily consent to GPS monitoring when the alternative is incarceration. I think that's an issue.
LaFrance makes that point.
Right.
But in LaFrance, the lawyer actually objected to putting him on the GPS. Here, his lawyer says, put him on the GPS and let him out, Judge.
In lieu of incarceration. So it was really a Hobson's kind of choice at that point. The other point, I think,
But again, why would we find you have any reasonable expectation? That data is being used just for the reason it's being put on him, which is to monitor, make sure he's not burglarizing homes, right? That's why he's being put on that, isn't it?
he's being put on the GPS monitoring, in my estimation, to ensure that he complies with the exclusionary zone that is a condition of his probation. And so
He's also not supposed to commit any crimes, right?
that's true, yes.
So when they use that data to determine whether he committed a crime, what privacy expectation does he have in that? I find that really hard to fathom, and maybe I'm just missing something.
Could you clarify, was he on probation when the police tried to access the data?
No, his probation had been terminated a year
Think that would
earlier.
make a difference if he was still on probation?
I don't think it would make a
No,
difference if
so
he
even a
were-
probationer would have a reasonable expectation of privacy in historical data
as against
against new
police
charges?
searches.
But not against the Department of Probation?
The probation would be able to search on a lesser standard that data.
What is the lesser standard?
The LaFrance standard is a warrant based on reasonable suspicion.
So
What
they
if they did that and they gave the police the information?
If they had did that for a truly probationary purpose, and then transferred or shared the information with police, that may have passed constitutional muster. I hadn't thought about that.
He knows the information is going to go to the police if he violates an exclusionary zone. If he commits a crime, he knows the information is going to the police. Why else would he be on a monitor?
I guess that's assuming that he violates the exclusionary zone. However, when he was put on GPS, he was given no information as to the technology. Now, this is 2012, and I think people.
Well, he knows they're going to put something on my leg and they're going to track me,
Right.
right? And the government's going to know where I am. And he has an expectation of privacy.
In the accumulation of his movements over time, people have expectations of privacy in that, and that's what Carpenter said, and that's what this court said. The voluntary consent, I think, is answered in Augustine and Carpenter, because in those cases the government made a similar argument. They said a person, by using a cell phone, voluntarily consents and hands over their location information to a third party, being the cell service provider, and therefore they can't have any reasonable expectation of privacy in that, and that was rejected.
The GPS device on the leg that tracks you by the government is the same as a cell phone in your pocket by a citizen?
Ultimately, the data that is accumulated over a long period of time that shows a person's intimate
You see no
detail.
difference in expectation of privacy in those two scenarios between a GPS strapped to your leg by the probation department and a cell phone in someone's pocket?
I don't necessarily see in what is gathered over time. I don't see a difference between the information's the same. The record, actually, the information in this case is far more.
Do you see a difference between his status as a probationer, as somebody who was actively on probation wearing the GPS, and being done with probation and no longer wearing the GPS, and yet the information gathered while wearing the GPS could be accessed afterwards? Don't you see a difference between those situations?
Well, I certainly there's a difference as his status is as a probationer. I think that's the difference.
No, but I think the question Justice Link asked inures to your client's benefit. I mean, this is archived forever. And the probationer certainly has a lesser expectation of privacy the implications of that, we don't necessarily have to reach in this case, during the probationary period. As Justice Graziano said, the thing's strapped to his leg. But 10 years later, 15 years later, that data is still there.
But why should that matter if the data is drawn from the probationary period? So they don't access it and you get a get out of jail free because they didn't use it during,
But they
it's not
could
like
access
they're
it with a
using.
warrant.
Statute of limitations would still apply.
Yeah, the statute of limitations I get applies, but I don't understand why if you did what you weren't supposed to do during the probationary period, why would it go away? So one day afterwards, they decide to access it and you don't have any ability to use that?
What about a warrant?
Right. I think it can be accessed with a warrant based on individualized suspicion under the Constitution.
So you need, if one day afterwards you access it, you need a warrant. But if you access it during the period, well, you're going to say you need a warrant either time. Yeah, I get that. But I just don't understand why why you have an expectation of privacy and data that's being collected, and you know it's being collected, and you know why it's being collected, and it kept you out of jail.
Well, I would suggest that it's unclear whether Mr. Johnson knew exactly what the GPS device was going to be doing in 2012.
What did he think it was going? What could any
He thought it
reasonable
would.
person?
I'm sorry.
What could any reasonable person think it's going to be used for?
His thought was that it would alert if he entered an exclusion zone, and that's why he thought he was on the GPS monitor.
And the exclusion zone only included what?
An address.
One address? It doesn't mean that even though he's been arrested for burglary, right? And he's a repeat offender at this point too, right? So,
Yes.
And he doesn't think that they're monitoring him for criminal activity, as Justice Budd asked earlier?
Well, I would hope that the GPS, the purposes of probation are rehabilitation and to ensure that the public safety. So
Pre-trial probation, though.
this is actually, no, it's,
It's pre-trial probation, right?
no, it's regular probation.
Regular probation, okay.
He was,
Yeah, the other Johnson case is pretrial.
that's right.
Sorry.
Yeah. So the, sort of probably too much of a question for this hearing, but the doctrinal framework just doesn't work. The Harlan concurrence from Katz doesn't work. If this is all okay because subjectively and objectively somebody knows that they're being monitored and that information is available for the rest of their life, then by its nature, we have a lot less rights under our Constitution than was available in 1789. It's constricting all the time.
That's right.
Does the framework work? I mean, the property framework from Jones doesn't work, does it?
No, I think what works is the Augustine framework.
What's reasonable?
Right, and that a person, the record of a person's physical movements over time, a person has a reasonable expectation of privacy in that information.
Maybe not as to the period when they're on probation. I mean, and used while they're on probation.
If used for a purely
Right.
probationary end,
Including Justice Budd's point that you can't commit crimes while you're on probation without violating it.
right, but if probation did, I would say that probation, when they have an alert or something, obviously they can look at some of the GPS data, because it's not over a long term. However, I don't think probation without a warrant based on reasonable suspicion can look, if he's gonna be off probation in a week, can go back over the 5 months and try to match up unsolved crimes with places that he was without getting a warrant based on reasonable suspicion.
The probation department couldn't even do that.
Could not do that, no. The probation department, if he has a reasonable expectation of privacy in this
Even a
record.
diminished one, even a diminished one?
Even a diminished one, because I look to the cases, the GPS, the surreptitious GPS cases, right? The people in those cases had a diminished expectation of privacy because they were in their cars on public ways. However, that didn't carry the day. A diminished expectation is not no expectation of privacy. And so when we're talking about the detailed compendium of a person's life, the familial, political, professional, religious, sexual associations that can be gleaned from this type of information, then a person has a reasonable expectation of privacy in it, then that means that in order to access that information, just as you would have to get a warrant to access a person's home or his person, even when on probation and even being a probation officer, you would need to get a warrant based on reasonable suspicion. I see my time is up, so unless there's anything further.
All right, thank you.
Thank you.
Ms. McKenna?
Good morning, if it please the court. Gail McKenna, Assistant District Attorney for the Commonwealth. I think the court's focused in on the issue here, which is whether or not the defendant had a subjective expectation of privacy or one that society would expect to be reasonable. And the Commonwealth's answer to that is no.
Not even after he finishes his probation?
No, especially not after he
Why?
finishes.
Well, then he's an ordinary citizen, isn't he?
Well, Your Honor,
He's done his time. He walks among us.
well, part of some of the objectives of probation of being on a bracelet are several, and they include deterrence, rehabilitation, and there's a statute that allows the probation department and the police to readily share this data, which is nothing more than court records.
The probation period, during the probation period. I'm talking about the probation period ending, the person having done his time.
There's
Why
no
doesn't
such
why doesn't he have-
restriction. Well, it's no different than a court record, like a docket.
That's not true. I mean, somebody couldn't walk up and say, give me the GPS information for a probationer, the same way you could walk into court and say, give me the court records for a probationer.
Well, that's only because we have a statute that says that they're not public record.
Right.
But for
So
that
it's- so
statute, all
it's-
these
so it's-
are is other court records that are only,
And, I mean, I understand that the police are given access to it, but not
Correct.
because it's equivalent to a court record. It's because the statute expressly says this information is available to the police, but not to a private citizen.
well, I would argue otherwise, Your Honor, that the only reason that these aren't completely public is because the statute says otherwise, and that they are to be shared by police. That's Section 100 of the probation code.
Sort of
These are just-
sort of a red herring anyway, though. I mean, that statute's not going to dictate the parameters of the constitutional reasonable expectation of privacy.
Well, I think to an extent it does, Your Honor, because what it shows is that the legislature is laying out what is reasonable under a societal interest, which is the legislature said it's reasonable that this should be shared with law
I'm
enforcement.
not sure that's what reasonable
not the public.
expectation of privacy means here. I mean, when you walk, most people know now, when you walk out the door with your cell phone, you're being followed. When you go through fast lane, you're being followed. When you use your debit card at CVS, you can be followed. And it goes on and on and on. And people realize that. That doesn't mean that they don't have a reasonable expectation of privacy of where they might be on any given second. I mean, the founders didn't think that we could be followed every single second.
Well, that's under Carpenter, Your Honor. That's when that was first established, because people actually do realize that they're being followed and they can turn their data
No,
off.
Carpenter's a game changer, no
But
doubt about
Carpenter's a
it.
game changer. This case is not. This case is someone who is a repeat offender, who went into court to be reprobated after violating his probation, asked to be put on a GPS bracelet, and was, in lieu of imprisonment, he faced 18 months of imprisonment, and he knew that he was to obey the laws. He was given the opportunity to rehabilitate himself. There was a deterrent effect, which was the bracelet was put on.
What do you do with LaFrance? Because LaFrance sort of wipes out the consent argument, doesn't it, somewhat?
You know, I think this is distinguishable, Your Honor.
I was trying to do that, but the only grounds I could come up with were that the lawyer sort of asked for it here while the lawyer objected to it there. But the U.S.,
know,
but we say that you can't really consent.
I think the problem with LaFrance is that it doesn't recognize that when someone commits a crime or violates the probation, there are going to be consequences.
Right.
And so at the point when you've done the violation, you've admitted to it, there's going to be a consequence. Had this gentleman been sent to jail, he could have been watched on a camera 24/7, and that could have been kept forever and searched forever without any restrictions or any problems whatsoever. There's nothing magical here about the technology, maintaining the data.
I follow you most of the way. I'm bothered by one thing, which is it does seem like it's some kind of search. I get that he knows he's being monitored. He absolutely should know why they're using it. His lawyer has told him, you know. What I find, though, is it's still some kind of search, isn't it? Particularly when you save the data and use it belatedly.
Well,
And
you know,
so
Your Honor,
so you still have no reasonable expectation of privacy in the fact that this data is going to sit around sort of like a loaded gun. And it bothers me because I know he knows he's being monitored, but I just...
he knows the data is being collected. He shows absolutely no interest in the fact, much like in Bly. But here's the thing.
Why?
Everything feels like a search to someone who is under scrutiny. If a police officer does what's perfectly permissible and walks up to someone on a sidewalk and looks them up and down, it may feel like they're being searched, but that's not subjectively or objectively reasonable.
So we don't need, because you have a tough time, right? If we find there's any expectation of privacy, is there reasonable suspicion to do this run afterwards to look through his data?
I do believe so, Your Honor.
And why?
Because based on the tip from the officers in Randolph who arrested this individual in the midst of a house break while wearing the bracelet. And so the information was obtained there, and it was a tip to our officers, and the police officers giving the tip, it was presumptively reasonable.
I think you can win even if we find a reasonable expectation of privacy?
Well, I do, Your Honor. But I don't think that you should find a reasonable expectation of privacy. I think it's unreasonable to do so, and I think society would find that unreasonable.
And can I ask you one last question?
I'm now thoroughly perplexed. You agree it's a search?
I don't, Your Honor. Because
How
if
can it
there's
not
no,
be viewed as a, well, let me,
in the same
it's not,
example,
I mean, hasn't the Supreme Court and us declared it to be a search?
no, Your Honor.
Isn't
They
there
have
a big
not.
difference between what can, the type of information that's collected?
I'm sorry?
The type of information that's collected helps make it a search.
I disagree, Your Honor. I think that whether or not there is a search here that the Constitution would be recognized under the Constitution is answered by the question whether there's a reasonable expectation of privacy. That's our law. And the example that I gave to Judge Kafka is a police officer can walk up into you in the street and look you up and down like this.
And you
may
also gave
feel
an
you've been
example of the
searched.
jail, the monitoring in the jail. But I don't find
Again,
that.
not a search.
Yes, but I don't find that at all comparable. I mean, because they're not looking at the same kinds of intrusive information that you collect in a GPS situation.
I would
mean,
disagree, Your
Walking
Honor.
around a cell and you're walking around the
Respectfully.
prison.
I would respectfully disagree because in the jail situation, you're being video monitored, you're
Well,
being
what are you doing in the
recorded.
prison? I mean, everything that you do in the prison is controlled.
Right, and this is
Everything that you're doing when you're wearing a GPS monitor is not. And so that you get.
you're being monitored by a GPS that you've agreed to put on your
Yes, but
ankle.
you're doing
and so,
things, you're doing things that you wouldn't do in prison and be seen, right?
But you should be doing it with the understanding that you're being tracked, and that's why you have no
How long are you gonna
privacy
be
right.
tracked? For how
You
long
don't
are you
have a
gonna be tracked?
privacy right to commit crimes, and you don't have a privacy right to disobey the order of a judge not to commit those crimes. This isn't a case where it was simply about an exclusionary zone. He was put on the GPS because he reoffended by committing more house breaks, and the judge, in a grant of discretion, permitted him to be on a bracelet. And if the court is to find that that the data is useless at the point when
Not useless. I mean, say it's 20 years later and it's a murder case. It's not useless. It's right there. Get a warrant. It's not useless.
But the government isn't required to have a warrant to access its own data. And the government isn't required to have a warrant to walk up to someone in the street and look at them, or to look at videotapes in jails. We don't need a warrant for every single thing that we do. And I think at the point when you take the Constitution and you elevate the fact that we need a warrant for things that we don't need warrants for instance, places where there's no expectation of privacy, you turn the warrant into a hoop that you have to jump through rather than a constitutional requirement, and it denigrates the need for a warrant.
I think you may have hit on something that is a possible distinction in my mind, and that is that you said that the government is not required to access its own data, or required a warrant to access. So whose data is that? And in Carpenter, was it Roberts or one of the concurring opinions that started to get at the property analysis, like bringing in a property analysis to data?
Well, and that's sort of the interesting thing that's happening at the Supreme Court, that this court has done a better job, I think, in balancing, is that the Supreme Court has been a little stronger on backing up to old-time property rights-based, expectation of privacy, and there's absolutely none here for him. But we still have the traditional privacy.
But that would make a difference then if we're talking about a person who's not, like credit card data would not be government data.
Correct.
And your cell phone data would not be government data. But your GPS data when you're on probation is government data.
Absolutely.
So that's a property analysis?
I'm saying that in this case, no, that it's not a property.
Whose data is it? Isn't that by looking at that? Whose
It
data
belongs to the government.
it belongs to? It's a property analysis.
Then it belongs to the government, and there's absolutely no privacy right whatsoever. In the traditional analysis, which is based on privacy rights alone, the expectation of privacy, which this court in Commonwealth versus Rousseau said was an important part of the analysis, and the court did that so that it could give standing to a passenger in a car. This court has said that that still is quite viable, and I think the Supreme Court is still operating on using both the property analysis, which the defendant has no property rights whatsoever here, and on the regular old-time expectation of privacy where there's no search in the constitutional sense when you have no expectation of privacy.
But, so I agree with that. I think that the property-based is sort of like a floor of constitutional protection to the defendant, and it may well be in certain circumstances that cats and reasonable expectation of privacy gives you enhanced protection. But I'm not so much bothered by whose data this is, because just like in Carpenter, saying that the third-party doctrine doesn't apply in these circumstances, to me the issue is, can this information of every place that you have been 24/7 during the probationary period be available for all time for the government to be able to utilize without a warrant? Not during the probationary period, but for all time.
Well, I think that the distinction made here is that there are statutes of limitation. We have a statute, 278A. We want this to be available to defendants so that they can go back in time and say, hey, I wasn't at a place, I was on a bracelet, so I'm exonerated.
No problem
I mean,
with
there
that.
are good
The
reasons.
Constitution's not there to protect
There are good
the
reasons.
government.
I'm sorry, I'm talking over you.
No, that's okay, but I mean, that's fine, but that doesn't apply here. The constitutional protection in this circumstance isn't to protect the government, and that's why I used the murder example, because there's no statute of limitation.
But I think I also have to talk about why it's important to keep the data and why we don't just throw data out, because we could simply say, well, gee, at the end of 5 years, it's gone. But I think that it's important to evaluate, too, whether or not someone is a good person to be on a bracelet. And it troubles me here that our trial judge here sentenced him to probation, and then put him back on a bracelet after he gets out of jail. I mean, this is clearly someone who doesn't exist well on a bracelet because he takes it as permission to commit more crimes. He's gaming the system. And that's the problem if you find a privacy right here where none exists at all, no law supports that there's a privacy right here, is that you're just encouraging people on the bracelet to game the system.
If he were not on probation, if he had not been convicted, and he would have a privacy right, correct? with regard to the GPS. You couldn't put the GPS on him without a search warrant.
This is a court order, not a search warrant that put the GPS on him.
We're not,
Well,
if he were not a defendant who had been convicted of a crime, you agree, I trust, under Carpenter and under Augustine, you would need a search warrant to put a GPS on him.
Well, the court put a GPS on him.
Try my question.
I mean, I'm not,
Try my question. If he were not a defendant, you would need a search warrant to put a GPS on him under Carpenter, correct?
for the police to put one on, yes.
Okay.
Of
So
course.
now he is, of course, a convicted defendant, and so the consequence is the same. There's a GPS on him. Isn't your argument that this is a lawful, not that it's not an invasion of privacy, but that it's a lawful invasion of privacy in the context of probation? It's lawful, that what the judge did was a lawful thing to do, not that it wasn't,
But I don't think
would not be
anyone,
a
I don't
search,
think
not that it
that's
would not be a...
contested.
Sorry?
I don't think that's even
Okay,
contested, Your Honor.
well, I mean, I gather it's not. So
Well,
now
you
the
contest,
question
you
is... now the-
contest whether there's an expectation of privacy at all, so
I do.
that's a difference.
But
So
the-
you
but the
haven't conceded
fact-
that point. I just want to make sure you understand where you're going with this.
But the fact that the judge put the bracelet on was completely legal, and he had a right to do that. But once the bracelet is on, there's no expectation of privacy in any of the data, because it's pursuant to an absolutely correct court order
Okay,
that's under his discretion that
but
he's
I'm not sure
allowed to
that's a
do.
reasonable expectation of privacy argument. You're saying that once there is a lawful search, the information that's obtained from that search becomes available to all for all time.
So long as, yes, I am. And if there's any other questions, I would
I
respectfully...
have one question on
Sure.
a separate matter, and it may be my own ignorance. When you get this data off of this GPS, does it put you inside the house, or does it just put you around the house? I mean, I'm trying to understand, I'm switching issues. The
Certainly.
sufficiency issue. The data from the GPS, does that literally put him inside these homes, or does it just put him with an overlay in the area? Because you
Both,
need to
Your
have
Honor.
him in the home, right?
Both.
So-
My trial attorney, Mr. Fahey, is here, and he's telling me both.
Okay, so there's no, in your view, there's no, that data, when we look at it, based on this record, it's going to show that he's inside the home.
Yes,
Okay.
yes.
The record shall reflect the nod, the affirmative nod of the
Which is
prosecutor
why I
in the
brought my
case.
intrepid trial attorney with me. Thank you all very much for your kind attention. I would respectfully ask that you affirm this conviction.